Please note that this AI-generated podcast is intended solely for general learning and educational purposes. While we strive to ensure accuracy, the AI may occasionally produce errors or incomplete information. We strongly encourage you to consult qualified professionals and conduct your own due diligence before making any legal, financial, or business decisions based on the content presented here.
Welcome back to the deep dive. Today, we're jumping right into a pretty high-stakes legal clash. It's between a global manufacturing giant, Saint Gobain, and, well, the famously rigorous Indian patent system.
That's right. We're looking at specialized glass coatings. The tech that helps keep buildings cool or gives cars that specific look.
Exactly. And the core source. It's a detailed judgment from the High Court of Delhi.
Yes, it's CA KOMM.IPD-PE-TESEA-820T. It's basically an appeal refusal against Saint Gobain Glass France. And honestly, if you want to understand how India tackles inventiveness in patents, this case is quite the masterclass.
Right. So our mission here is to unpack this. Saint Gobain, huge company, right? But they couldn't convince the Indian Patent Office or the High Court that their tweaks to known glass layers were truly inventive.
Yeah, the question is why? What did they claim? And crucially, where did they go wrong in proving that inventive step?
Okay, let's ground this. Lay out the basic case details for us.
Sure. The case is, as I said, CA POMM.IPD-TPT 13/2024. It's from the High Court of Delhi at New Delhi.
And the judgment date.
Judgment was delivered September 11th, 2025. It was reserved earlier, back in July. The judge was the Honorable Mr. Justice Amit Bansal.
Got it. And the parties involved.
The appellant, the one appealing the refusal, was Saint Gobain Glass France. They had Mr. Himat Singh and his team representing them.
A big player in glass R&D and manufacturing.
Absolutely. Architectural glass, automotive, you name it.
Yeah.
Then the respondents. First, the Assistant Controller of Patents and Designs, represented by Mr. Nishant Gautam's team.
Okay.
And respondent number 2, who was actually the one who filed an opposition before the patent was granted, they were represented by Mr. Ranjan Narula.
So a pre-grant opposition, that adds another layer. Okay, let's trace the timeline. How did the specific application get started?
So Saint Gobain filed this application, number 27717045317. The title was Material Comprising a Stack of Thin Layers, basically glass coating.
And this was filed in India when?
Filed in 2017. It was a national phase entry based on an international PCT application, claiming priority back to 2015.
Standard procedure. But problems started early.
Pretty quickly. The first examination report, the FER, came out in April 2019. And it raised some serious objections right away.
Like what?
Lack of novelty, but the big one was lack of inventive step. That's Section 2.1 of the Patents Act. Also some issues under Section 3T and clarity under Section 10.
And then the opposition landed.
Yes. Respondent number 2 filed that pre-grant opposition in August 2019. So the controller was looking at the examiner's report and the opponent's arguments.
Did Saint Gobain try to fix things? Amend the claims?
They did. They actually amended the main independent claim, removing an optional layer, something called the lower blocking layer, or LBL.
But it wasn't enough.
Apparently not. The assistant controller issued the final refusal on January 5, 2024. And the core reason cited: lack of inventive step under Section 2.1, tied also to the opposition ground under Section 25.1.
Which brings us to the appeal before the High Court.
Exactly. Saint Gobain appealed under Section 117A of the Act.
So boiling it down, the central legal question for Justice Bansal was,
did the controller mess up? Did he wrongly conclude that this specific glass coating stack, which aimed for certain optical properties like light reflection over 30% using specific layer thicknesses, did it actually lack an inventive step under Indian law?
Okay. Saint Gobain obviously thought the controller did mess up. What were their main arguments on appeal? They must have come out swinging.
Oh, absolutely. Their first point was straightforward. The controller just failed to appreciate the technical leap, the advancement over what was already known, the prior art.
They felt their specific recipe was genuinely better and non-obvious.
Yes, and linked to that was their second major argument. The controller used improper reasoning, specifically hindsight reconstruction.
Ah, the mosaicing argument. We hear that a lot in patent cases.
Exactly. They accuse the controller of cherry-picking little bits from different existing patents, documents A, B, D2, and others, and sticking them together after knowing Saint Gobain's invention to make it look obvious.
Their point being that a real person skilled in the art, a PSITA, wouldn't have been motivated to combine those specific bits in that specific way back then.
Precisely. They argue there was no teaching, suggestion, or motivation in the prior art to combine those elements to arrive at their claimed invention. It only looked obvious in retrospect.
What else do they argue? Did they bring up their data?
They did. They heavily relied on their experimental data, tables 2 and 3 in the patent specification, and also an expert affidavit from a Mr. Udatendu Mukhopadhyay. They claimed this data proved the technical advancement and non-obviousness.
And they felt the controller wrongly dismissed this evidence.
Yes. They argued it was contradictory. The controller had apparently accepted the disclosure was sufficient under Section 10, meaning they'd explained how to make the coating. So St. Gobain argued, how could the controller then say the data proving its merit was insufficient? It seemed inconsistent to them.
Okay, that makes sense as an argument. Anything else? The foreign patents.
Ah, yes, the classic argument. Look, this patent was granted elsewhere. They pointed specifically to the grant by the European Patent Office, suggesting the Indian office should take that into consideration.
Right. So how did the respondents, the controller, and the opponent push back against all that?
Well, first, on the foreign grant point, they were unified and blunt. Irrelevant. Patent rights are territorial. What happens in the EPO doesn't bind India, full stop.
Standard response, but important. What about the core inventive step issue?
The Controller's Counsel argued the refusal was based on a thorough examination. It wasn't about disclosure, Section 10. It was purely about the lack of inventive step, Section 2.1.
And their reasoning for why it lacked inventive step.
They framed it as mere optimization. They said St. Gobain was just tweaking known parameters, layer materials, thicknesses, things someone skilled in the art would routinely adjust to get desired optical or solar properties. No real invention needed, just standard work.
So predictable results from routine adjustments. What about the opponent respondent too?
They strongly supported the controller. They specifically mentioned the 5-step framework for obviousness laid out in the F. Hoffman-LaRoche v. Thipla case, arguing the controller applied it correctly.
And their take on the technology itself.
Very similar to the controllers, they argued the basic structure, silver layer, dielectric layers, blocking layers, that's all well known in glass coatings, fine-tuning the thicknesses to hit certain reflection or color targets. That's just obvious optimization for a PSI.
Okay, so the battle lines were clearly drawn. Optimization versus genuine technical leap. How did the High Court rule in the end?
The High Court came down firmly on the side of the respondents. The appeal was dismissed.
Dismissed. So the controller's refusal stands.
Correct. The interim order that kept the application sort of pending during the appeal was also vacated. It's a definitive rejection.
Right. Let's get into the court's reasoning then. This is the crucial part. Why did the court agree it lacked inventive step? Was it more about the legal test or the evidence St. Gobain presented?
It was fundamentally a failure of the evidence. The court really hammered this point. If you're claiming technical advancement, especially for something that looks like optimization, you must back it up with solid, objective, comparative, experimental data.
The data has to do the talking.
Exactly. And St. Gobain's data, according to Justice Banzal, just didn't hold up under scrutiny. It actually undermined their own case in several ways.
Okay, let's hear the specifics. What were the major flaws the court found in their data?
Well, there were a few really damaging ones. First, remember how St. Gobain amended their main claim to remove the lower blocking layer, the LBL?
Yes.
Okay, well, the comparative experimental data they provided in Table 3 of their specification, the data meant to show superiority still included results for configurations with the LBL.
Wait, so the proof they offered didn't actually match the invention they were trying to patent in the end?
Precisely. The court basically said, this data is irrelevant to the claim as it currently stands. That's a huge own goal.
Wow. Okay, that's bad. What else?
Second, the court looked at the performance targets St. Gobain was claiming to achieve. Things like solar factor, light reflection over 30%, specific color values for that shiny silver look.
Right, the alleged technical advantage.
Well, the court pointed out that one of St. Gobain's own comparative examples in their data, a material labeled Saint-Piece Octenbrug, already met those key technical targets.
So their own baseline comparison did what they claimed their invention uniquely did.
Essentially, yes. If your comparison material already achieves the inventive result, it strongly suggests the claimed features aren't producing a non-obvious technical effect. The alleged advancement wasn't really there compared to something quite similar.
That seems pretty damning. Was there a third issue with the evidence? You mentioned an expert affidavit.
Yes, the affidavit from Mr. Mukhopadhyay. The court found issues there too. It noted that the affidavit compared two materials, A and B, but it selectively omitted some key performance parameters like the solar factor, G value, and total energy transmission, T.
Why is that bad?
Because the patent claimed a balanced performance across multiple parameters. By leaving some out, The affidavit didn't provide a complete picture to prove that overall balance was achieved and superior.
Cherry-picking the data within the affidavit itself.
It appeared that way.
Yeah.
And maybe the biggest blow to credibility came from this affidavit, too. The court found that the expert affidavit changed the target values for the reflection color coordinates, Rx and Brext, compared to what was originally stated in the patent specification.
They move the goalposts.
That's exactly how the court saw it. Changing the targets you're trying to hit midway through the process severely damages the reliability and credibility of your evidence.
Okay, so the data was just full of holes. What about the mosaicing argument? Did the court buy Saint Gobain's claim that the controller unfairly stitched together prior art?
No, the court didn't buy it at all. Justice Bansal explicitly rejected the idea that this was improper hindsight. The court referred to established principles, even citing the Manual of Patent Office Practice and Procedure and Territorial on the law of patents.
And what do those principles say about mosaicing?
They basically say mosaicing is permissible, even expected, if the prior art documents are all within the same technical field and relate to the inventive concept. And importantly, if a person skilled in the art, PSI, would be motivated to look at them together.
So, in this case,
all the cited documents, A, B, D2, and those other application numbers, they all related to multi-layered silver-based coatings for solar or optical control on glass. They were squarely in the same field.
makes sense that someone working on this would look at all of them.
Exactly. The court concluded that a PSI would naturally consult and potentially combine teachings from these related documents. Therefore, finding the invention obvious based on combining them wasn't hindsight. It was reflecting the expected knowledge and approach of a skilled person.
Which brings us to the legal standards and precedents the court used. What specific laws and cases underpinned this reasoning?
The core statute, of course, is the Patents Act, 1970, especially Section 2.1, which defines inventive step. But the court leaned on several key Supreme Court and High Court precedents to interpret that.
Which ones were most important?
Well, for the general test, Novartis AG Union of India was relevant. It set out that three-step requirement. New, capable of industrial application, and involving a technical advance or economic significance, making it non-obvious.
Okay.
For the nitty-gritty of determining obviousness, the court looked to the five-step test from F. Hoffman-LaRoche, Ltd v. Cipla, Ltd. It provides a structured way to assess obviousness.
And you mentioned the standard for the person skilled in the art, the PSI. Was there a key case for that?
Absolutely crucial here was Rhodia Operations v. Controller Patents and Designs. This Delhi High Court decision is significant because it explicitly defined the Indian PSI standard as being quite high.
Higher than other places, maybe.
Arguably, yes. Rhodia established that the Indian PSI isn't just an ordinary skilled person. They're assumed to have greater than average competence in the field, plus relevant qualifications and common sense. And critically, they're presumed to know all the relevant prior art.
So if something would be obvious to this super skilled person, even if it took some routine work, it's not inventive in India.
That's the implication. It raises the bar. It has to be more than just a workshop improvement, as the old Bishwanath Prasad Radheshyam case put it. It can't just be a predictable outcome of optimization.
And the court explicitly rejected the relevance of the European patent grant.
Yes, reaffirm the principle of territoriality. What happens elsewhere doesn't dictate the outcome in India under Indian law and standards.
Understood. Quick question, any dissenting or concurring opinions mentioned?
No, none mentioned the judgment summary. It was a single-judge bench, Justice Amit Bansal, delivering the opinion for the court.
Okay, so pulling this all together, what's the real legal significance here? What's the precedential weight of this decision?
I think it has several important implications. First, it strongly reinforces that high PSI standard established in Rhodia. Companies need to realize the benchmark for non-obviousness in India is demanding, especially for optimization inventions.
So, expect tougher scrutiny.
Definitely. Second, it gives a clear judicial stamp of approval to the practice of mosaicing-related prior art documents when assessing obviousness. As long as the documents are in the same field and a PSI would look at them, combining them is fair game.
That clarifies things for examiners and applicants. What else?
It also draws a very clear line between meeting disclosure requirements under Section 10 and proving inventive step under Section 2.1.
Yeah.
Just because you've explained how to make something doesn't mean you've proven it was non-obvious to create. They are separate hurdles, and the evidence for the latter needs to be robust.
Evidence is key. which leads perfectly into the final question. What's the single most important takeaway from this whole case?
For me, it boils down to this: evidence, evidence, evidence. Particularly for inventions that involve optimizing known components, like adjusting layer thicknesses in this case. Securing a patent in India absolutely hinges on providing credible, comprehensive, and non-contradictory comparative experimental data.
Not just any data, but data that proves.
Data that proves an unexpected technical effect or advantage. It has to show a genuine leap, not just the predictable result of routine fine-tuning. If your data is flawed, contradictory, incomplete, or as here shows your own comparison meets the targets, you're likely going to fail the inventive step test.
So a major global company, successful in Europe, failed in India because their evidence didn't meet that high bar. They couldn't demonstrate that crucial, non-obvious technical leap.
That sums it up perfectly. The court needed to see the inventive spark in the data, and instead they saw routine optimization with predictable outcomes and shaky evidence.
It's a stark reminder of how different patent regimes can be and the specific demands of Indian patent law. Minor tweaks without a clear, unexpected benefit just won't cut it.
And that leaves us, and you, the listener, with something to chew on. Think about this. Saint Gobain's own comparison material, CMP3, apparently met the key targets they were claiming as inventive for their new product. Does this judgment suggest the Indian system is working as intended, preventing companies from getting extended protection evergreening for just incremental, predictable improvements?
That's a really interesting question.
And maybe ask yourself, if you were assessing this, what kind of specific, objective data, beyond just hitting slightly different numbers, would truly convince you that an invention in this field of complex glass coatings was genuinely non-obvious and inventive? What does that spark look like in hard data?
A high standard indeed. Food for thought. Thank you for walking us through this complex but really illustrative case.
My pleasure. It's a significant one.
You've been listening to The Deep Dive. Join us next time as we unpack another crucial piece of the puzzle.